Hello, everyone, and welcome to the Your Mark on the World show. I'm your host, Devin Thorpe, and we're producing this episode for GoodCrowd.info. Our guest today is one of my great friends, one of our sponsors for the Good Crowd 14 conference, and one of the truly great minds in the legal arena around crowdfunding. Really the leading expert in this space, Douglas Ellenoff. Doug, thank you very much for joining us today.
You're very welcome, Devin. It's great to see you as always, and thank you for the kind words. It's actually you who's doing the good work in the crowdfunding industry for a lot of deserving countries and people around the globe, and I'm just a facilitator.
Well, you're doing remarkable work, and you sent me and your other clients an alert recently about some coming enforcement from the SEC, and of course everyone ought to be complying with all securities rules all the time, but this one got my attention. The issue was related to something called touting. Doug, explain to us what the issue is, and then we'll talk about what to do about it.
Fair enough, Devin. I mean, what happens in all securities programs, there is an evolution, particularly in a new program like crowdfunding, where it's the accredited crowdfunding provisions under Title II that you and I have spoken about previously, or what will happen in Title III. But all my other securities programs that we've either helped establish or develop over time, you always have to be surveilling what the current zeitgeist is, whether it's with the federal regulators, the state regulators, or even commercially, to make sure that you're at the cutting edge of what's going on to avoid problems, because everything changes dynamically. Even IPOs and regular financings that we do, things develop and you need to stay abreast of those changes. Every year, the SEC gives a list of priority areas where they're going to devote their resources and allocate time and energy to go after what they perceive to be problem spots, or what may be problem spots. And so the SEC has flagged crowdfunding at large as an area of potential concern for them. And so touting is their way of saying that beware, we're watching this industry, and where appropriate, we will bring enforcement actions. And what we do as a community service to our clients, but in this case, the broader crowdfunding community, of which you know that we have an active role and engagement, we want to avoid problems for folks, whether or not we represent them or not, because it is not good for us or our clients if there are problems anywhere in the crowdfunding universe. So this was our alert to the world at large to say, here are those issues that the SEC has flagged as being sensitive, and we wanted to sensitize the crowdfunding community to these issues to make sure they avoid these potential problems.
Yeah, so the issue here seems to center on disclosure of compensation. The SEC seems to be anxious about the portals not fully disclosing the fee arrangements with the customers. And I guess in a broader context, the SEC is worried about intermediaries acting on behalf of pitching a security without disclosing that they're getting paid to do that, right?
Yes. We sent out the alert including Section 17 related issues, which you're specifically referring to, because we have seen over the last year since Title II went live on September 23rd, 2013, regulators, whether they be a state or federal, take actions, whether or not it's just visiting a crowdfunding portal, sending in a letter, making a phone call, or even subpoenaing clients, meaning funding portals, and issuers to see how they've undertaken certain transactions since Title II went live last year. The good news is most of the investigations to date have resulted in really educating the regulators that the clients are actually doing it appropriately, and so there haven't really been many actions that have resulted in consequences to the client, to our clients anyway. And I think generally speaking, people are trying to do things the way they're supposed to. In that same alert, we mentioned one enforcement action that the SEC made where, in fact, it resulted in a settlement. It was fairly modest in nature and scope, but at the same time, it was telling, as part of this touting, that the SEC is looking at the conduct in crowdfunding to make sure that it's being undertaken responsibly. The Section 17 fee issue that you raised, which is not unlike mutual funds or truthfully any securities program where the SEC wants investors to understand what the economic incentives are so that they can decide whether or not their interests are aligned with the funding platform in this particular case or not. So what the SEC is asking in this situation is don't bury the arrangement in the transaction documentation. Make some express statement of disclosure on the funding platform itself as to how the funding platform is being compensated. And given that there are several different models that funding platforms are operating under, they want the funding platforms to be clear on that point. So to put a finer point on it, there are funding platforms, Devin, that only accept money to post their deal to their site, and their only economic incentive is a posting fee like advertising in a newspaper. And as long as they say that, then I think an investor can understand there's been limited curation, limited due diligence potentially, and that they're not being paid a brokerage fee or what we call a performance-based compensation. If you're a broker-dealer funding platform, you're entitled to take a brokerage commission, and therefore investors ought to know that every dollar they're putting up for a potential portfolio company on that platform, some percentage of that is coming off the top, and that's how that funding platform's being paid. And that needs to be disclosed in the terms of use and elsewhere on the funding platform, so there's no confusion. And then the last, which is more complicated, is where the funding platform is acting like a venture capital firm or a real estate investment firm, where they're actually participating in the future outcome and result of the underlying investment, whether it's real estate or a venture capital deal. What we call performance-based compensation, sometimes referred to as a 20% incentive fee, or if it's a real estate deal, it's part of the income that's being thrown off the waterfall, as we call it. And even if you can't specifically give a percentage, because maybe your platform takes different amounts for different deals, you need to highlight that you're doing it generally, and then you need to flag for investors where they need to go look to see what the actual compensation being paid will be, and it should not be just buried in some pro forma financial statements where maybe less sophisticated investors don't really know how to read it.
Does the SEC have any preference among compensation models?
No, I wouldn't characterize it that way. I just think there are different regulatory implications, Devin, depending on how you do it. I think if you're a posting site, that's the least regulatorily sensitive, and consequently probably doesn't get the SEC's attention as much. But you do have to disclose that you're getting advertising-like fees. The broker-dealer compensation model, you have to be a broker-dealer. There's no ambiguity about it. If you're taking what's called transaction-based compensation, you have to be a broker-dealer, or there are variations of that where the principals of the funding platform may be licensed securities professional and then have a relationship with an actual broker-dealer with the funding platform in an affiliated relationship, and that should be disclosed as well. And then the last one, which is not regulated the way a broker-dealer might be, is again the situation where the funding platform acts like a general partner in an investment firm. And we believe that while the SEC doesn't have immediate regulatory authority over that business model, that it is prudent, given the high-profile nature of funding platform activity, for funding platforms to be careful that they're complying with the exemptions from broker-dealer registration or being a registered investment advisor, or they will find that that is a certain thrust of regulatory enforcement activity currently, and that's what we're advising people to be concerned about.
This risk seems to apply primarily to the portals, the platforms, the brokers, the intermediaries. Does it extend in some way to the issuers, the companies that are raising money?
Unquestionably. The best example is having nothing to do with the Section 17 issues, but having to do with the verifying of the accreditation of the investors. Many issuers are relying on the funding platform to be doing the verification, but if the platform, for one reason or another, is not doing it correctly itself or through a third-party verification service provider, it's actually the issuer who has the liability directly and will find themselves subject to a rescission right that the investor can ask for their money back because it wasn't done properly for federal securities law purposes or for blue sky related purposes, which is the state securities laws.
Sure, sure. Well, this sounds very menacing. Before we wrap up, I want to make sure people understand and have a good sense that this is a manageable, if you will, acceptable risk if you're managing it well. I don't want people to not crowdfund, to not raise money this way because of a fear of this regulation.
And I'm very glad that you brought it up, Devin, because I think that is important. A lot of things seem very scary or menacing, as the word you used, but if you get appropriate counsel who understands the rules of engagement of securities laws, in particular under the crowdfunding provisions, and there are many professionals out there to engage in conversation with, you won't have a problem. Like I said, we've already had clients that have undergone through a certain amount of review and investigation, not necessarily on the Section 17 issues, but on some of these other issues. And while I'd like to think that we've given very good counsel, I think more importantly, they have taken to heart the concern that this is a regulatory sensitive arena. The SEC is spending time, energy, and resources making sure that this ends up not being a problem for themselves. And consequently, if the client really implements good process and procedures with excellent record keeping, which we emphasize in that client alert, we do not believe this is anything other than something to be aware of, and you should absolutely not proceed in crowdfunding because of it. It's just that for folks who are not securities law professionals or finance professionals, this is the sale of securities. I know you understand this. It's highly sensitive. We're dealing with investors' capital, and you need to trust. You need to treat that responsibility extremely seriously, as if it was your own money or your own family's money, so that you wouldn't do anything to them that you wouldn't do to yourself. And for those people who don't have the appropriate ethical standards in mind, then just don't do it. But yes, I think this is to capture the outlier bad actor, not the vast majority of people who you and I have met over the last 3 years at this point who are trying to do it right.
Yeah. Well, Doug, I really appreciate you taking the time to be with us today. I want to ask you one thought question here before we wrap up. You have been really engaged from the very earliest days of this crowdfunding, what I want to call movement. It's more than a regulatory evolution or regulatory change. We're really talking about a movement, a shift in attitudes around capital raising. I wonder why you think this is so important. Why do you care about this shift, this movement in the capital markets toward crowdfunding?
First and foremost, I think it's just right-minded. I think it's timely. I think what's going on with the internet and has for a decade makes what you and I are spending a lot of time on important just in the big picture sense. What we're talking about today as it relates to the crowdfunding that's being conducted online today, that's entrepreneurs raising money from wealthy people. And while Commercially, I think that's right-minded and directionally the right thing for entrepreneurship. You and I actually spend more of our time focused on other aspects of crowdfunding, where it's crowdfunding in your case for good humanitarian reasons, or not that I don't think that's important, because obviously I do, and that's why I love supporting you and what you do. But I also believe in the unaccredited crowdfunding, which is the Title III crowdfunding. It's not permissible today, because I think as important it is for Americans and in democracy for people to vote, I think all people should have the opportunity to invest in a capitalist society. And it's not right just for the 1%. So while I'm thrilled with what we've achieved so far, I am quite dismayed by my lack of achievement in my advocacy for Title III. But I do believe when we make all those things happen, a lot of the current disquiet, if that's such a word, or unrest in certain parts of the world could be reduced if people are actually brought into the capitalist system. And I think it's good for countries at large. You know, I was in Singapore and Thailand and Malaysia and Hong Kong and going to Japan, and it's all, and lots of friends of mine, your friends, Woody and Jason, spent a lot of time in the MENA countries and in South America. And it's in those countries in particular, not that it's not healthy for the U.S., because it will be, to bring everybody into the process and make sure that they feel that they're participating and they have the opportunity to make money like everybody else and do good like you do every day.
Yeah. Well, I couldn't have said it better. I really appreciate the sentiment. Doug, I want to just follow up on one thing. No one understands why and when, but the SEC has chosen not to issue final regs. Why do you think they haven't? When do you think they will?
And there are a lot of different ways to answer that. There's the highly cynical answer. I actually just think the people at the SEC have been extremely genuine as individuals in crafting those 585 pages that you know were that came out last year and published October 23rd of last year. However, there is a belief that allowing unaccredited, not people who are not of means, to invest any amount of money in this sort of activity is not something they want to see proceed. And so I don't think it matters what the rules said. I actually think the rules are extremely balanced. While there are things I'd like to see done differently, I don't think that it's a reason for not proceeding. I think you finalize the rule, you create the industry, and if it doesn't work, you fix it. The irony may be, Devin, that with Republicans controlling both sides of Congress now, they may impose upon the SEC new versions of the rules that actually are more commercially viable, but maybe a little more tilted on balance for the entrepreneur than investor protection. And so I'm sorry to report that, because I actually think the current construct is enlightened and fair-minded. And the answer to your question is, if left to their own, I think the SEC has made it clear as of last week that the proposed rules won't be finalized until October of 2015, and that's only a target still, whereas I actually think that the Republican Party is going to bring a lot of pressure to bear, and it may very well happen sooner, but as I said, in a form that is a little less interesting to me as a professional.
Now, very interesting. Well, it will be exciting to see those rules come out whenever they come out. I certainly haven't anticipated a regulatory change in my whole entire life with the level of anticipation I anticipate these, and I suspect that there are thousands of people who are doing the same thing, waiting with bated breath to see when those rules will come out. Again, Doug, thank you very much for being with us today. Tell people quickly how they can track you down if they need a good attorney.
That's nice of you, Devin. The name is Doug Ellenoff. The firm is Ellenoff Grossman Schole, and the website is egsllp.com, or you can follow me on Twitter at Douglas Ellenoff.
Fantastic. Doug, thanks again for being with us today. It's been a
Devin,
joy to have you.
Can't wait to see you in person.
All righty. Let's do some good.